the matter of Jazztel PLC and the Commissioners of Her Majesty's Revenue and Customs?
Mr. Baldry.
My Lords, we were considering the decision of the Supreme Court in FII, and that Authorities Bundle 2, tab 8. And we'd arrived at page 384.
Yep.
And I showed you that Lord Reed and Lord Hodge had just considered the point in time when a claimant is treated as acquiring knowledge, the requisite knowledge for the purposes of section 11 and 14 of the Limitation Act, and that is the test which they go on to say is to be brought into section 32 1C, in particular the Hayward and Fawcett's test of knowing with sufficient confidence to justify embarking on the preliminaries to the issue of the writ. At 191 and at the end of 191 and the end of 193, they make the point that they consider the Hayward and Fawcett's test to be consistent with Lord Brown's formulation of the worthwhile claim, and they make the point that each concept helps and casts light on the other. So, in terms of recognising that a worthwhile claim exists, it exists at the time, you know, with sufficient confidence to justify embarking on the preliminaries to the issue of the writ. And if you've got to the stage of being justified to embarking on the preliminaries, you have a worthwhile claim for these purposes. And it's clear from this that it doesn't mean that you need to have reached the view that your case is going to succeed. I mean, at 192, they sort of deal with some practical examples and make the general point that the limitation period normally begins to run on the date when the cause of action accrues. So if in a tort case there is an incident which gives rise to a cause of action, generally that's when the cause of action arises, and it's not postponed until the individual claimant completes his investigations. Indeed, there may be all sorts of legal or practical difficulties that means the claim in question won't succeed, but that doesn't mean that the limitation period stops running.
I'm not sure how persuasive that analogy is, with respect, because you know all the facts which go to constitute the cause of action. Isn't the problem with a restitutionary claim for mistake of law that one of the essential ingredients of the cause of action is not known to you yet?
The fact that you will succeed is not relevant. The fact that will justify starting the investigation into whether there might be a mistake of law can take place well before you know that there is a mistake of law. It's a question of belief, and one then looks first of all at the circumstances of the individual claimant to see whether that claimant is in the position where he is justified to embark on the individual inquiries, which will depend on what he knows and what his beliefs are. That's limb 1 of the test. And then limb 2 of the test, if one can't show that individual claimant knows, then there is the reasonable diligence test, which, again, as we'll see, imports a number of assumptions, like you've got to look at the business concerned and the resources available to that business, and assume a person who's willing to find out his mistake. So, in the world that we are in, we're assuming multinational corporations with advisors doing SDRT transactions, and what happens on a large-scale SDRT transaction. So all those factors are fed in, even though you don't know. But, of course, we say in the present case, it's quite a straightforward case because of the advice that was given. Jazztel was put in the position where it was justified to do what it did, investigate and make a claim to the revenue. So even though the mistake of law is not known, there is that much lower degree of threshold that there was under the test in DMG. But I accept your Lordship's point that there is a conceptual difference between the mistake of law and the sort of being knocked down.
Yes.
But nevertheless, that's the much lower threshold that applies in those cases, which is being adopted. I think the point I was really trying to make from 192 is that you might start your investigations. You might believe, or your solicitor might advise you, well, there's a possible claim here. The result of the investigations might be that the advice is, well, actually, you don't have a claim. You're going to lose because you can't prove causation or whatever it is. Or you might be told that, well, you've got a potential claim, but the defendant really hasn't got any money, so there's no much point in progressing that claim. Or you might be told, well, you've got a potential claim, but it's going to cost you an awful lot of money to do it. So maybe wait and see, because somebody else might make a claim. All those range of possibilities might arise from the investigation that you carry out, but the result of all those points would not stop time running against you, because once you've got to the stage of being justified to make the investigations, that's when time stops running. So I see that your Lordships have asked for some further cases that the Deutsche Morgen Howard and Fawcett itself. I'll have to refresh myself what Howard and Fawcett said, but I do know the AB and Ministry of Defence case.
Maybe we should have that one too.
We'll bring that one as well. that was the talked case concerning the servicemen who had been exposed to radiation, and they formed the belief that the radiation was attributable to the Ministry of Defence. Way before issuing their claim. So they had a belief that the radiation was caused by the Ministry of Defence, and the actual events took place in the 1950s. They brought claims in that case in 2004, but they argued that they weren't time barred because they only acquired the knowledge that their injuries were attributable to the defendants in 2007. So claim in 2004. 2007 they say, now we've got knowledge because we've got an expert's report at that stage which enables us to form the view that the radiation was attributable to the Ministry of Defence. And what the House of Lords said in that case was, well, you can't argue that that you had no knowledge of the fact of attribution until the time you got your expert's report in 2007, because you already made your claim in 2004. And one of the points in that case was that the that the claimants were accepting at the time of this limitation issue being decided that they couldn't prove causation. They were unable to prove causation still, so at the time the case was being decided, they couldn't prove their claim. But Lord Wilson said, well, that's irrelevant to the fact that they formed the belief with sufficient justification to investigate the claim many years before. So you may not be able to prove your claim. You may be told that it's not in your sort of financial interest to pursue the claim because the defendant doesn't have the resources. You may be told that in the scale of things, your claim is too small to justify going further. But wait and see, another taxpayer, another claimant may raise the point. All those matters are irrelevant.
So what is the heart of the test? Is it? I mean, we've got the two formulations: sufficient confidence to justify embarking on the preliminaries, recognising that a worthwhile claim exists. And I think you're saying, well, it doesn't matter whether you think the defendant is good for the money. It doesn't matter whether the defendant is going to oppose your claim fiercely.
Yes.
So what is the test?
I don't want to sort of re-describe the test is as set out here.
Well, one of the problems we have is that these two alternative ways of putting it are repeated verbatim in many, throughout the judgment, almost a kind of leitmotif. So the Supreme Court is very deliberately not elucidating the content beyond repeating these sort of key phrases. We've got to apply them. To do that, we've got to understand what they mean.
Yes, but at the same time, they clearly think they are articulating the same test.
They do, they say that.
So we're not sort of struggling. These are both informs the other. I think what I would say about the two tests is that Lord Brown's test is a much looser, standing back from it, worthwhile claim.
Yeah.
One can't take too much into that and say, oh, that must mean a claim that you're advised is worth taking to the court, because it's absolutely clear from cases like A and B, and from what the lordships Lord Reed's and Lord Hodges saying at 192. Yes. That, you might be told that the investigation, your claim isn't a good claim, but that's not the test. As soon as you know that you've got some information or belief to justify the investigations, and particularly if you've got to the stage where you're justified in sending a claim out to the defendant which articulates the mistake that you've made, by that stage you have a sufficiently worthwhile claim for limitation to stop running.
Well, I can see if it's a kind of area where there are protocols which say before making a claim you should send a pre-action letter and so forth. That plainly must suffice if you're in a position to send a proper pre-action letter without necessarily being able at that point to say I've actually got evidence to support every single bit of my cause of action. I mean, that was your causation point.
Well, that would be extremely, yes, but absolutely no doubt.
On the other hand, it can't be just pure speculation.
No, not
so. I mean, there's a lot of grey areas in the middle.
Not pure. So the claimant that just said, well, maybe I don't know, maybe this law could be wrong. Well, no.
Or let's chance it in the hope of getting an offer.
But
I mean, that's difficult. I mean, where does that come down?
Because if before making that sort of decision, the claimant has sort of begun the investigation. So, well, I think this is worth investigating. And so one of the causes of that might be that you're told, well, no, you don't have a very good claim, but give it a go.
Is it just investigating? It's justify embarking on the preliminaries to the issue of a writ. That seems to be a bit beyond investigation.
I think that there was the sort of concluding, the investigation is a kind of summary of all that at the end of the comment of 1433.
Sorry.
The quote from Howard and Fawcett.
I see, yes. Yes, I see.
So knowing was sufficient to justify embarking on the preliminaries.
Yeah.
But taking advice.
So basically, taking any advice at all. So it just occurs to me there could conceivably be a claim. I go and get advice. Have I at that point crossed the Rubicon?
Yes. We're looking here at the 32(1)(c). Ordinarily, your limitation period arises when the incident happens. So here we've got a provision which is saying you can have an extension of that time. And what the test is saying, that once you reach the stage of having a belief that justifies you asking about whether you've made a mistake, you can't then just sit back and rely on the extension.
And let me just put it a different way. Suppose you haven't yet got any advice, but you have views on the thing, and do you think you have a 40% chance of success? Is that a worthwhile claim?
If you do think yourself justified to take advice, yes. If taking all the circumstances into account, such as the nature of the person and the type of the claim, then a reasonably diligent person having those doubts would think it worth investigating, yes, and the fact that he thinks it's a 20%, 40% claim or a 60% claim doesn't really matter. What matters is that has he formed the belief that it's something that might form the basis of a cause of action. Once you've got to that stage,
You've formulated it several times in terms of belief, but I thought the test was an objective one, not what this particular person believed.
There are
whether with reasonable diligence they could have done various things.
There are the two limbs to the test, and when in the summary of the test that they make a 2091, which we'll come to, is that the test of discoverability is that the mistake of law is discoverable when the claimant knows, or could with reasonable diligence know, that he had made such a mistake. So the second limb is a more objective test, and one's got to look at imbuing this claimant with the sort of attributes he is to be imbued with. Would it be reasonable for him to have this belief?
Yes.
The first limb is more subjective in the sense that one is asking of this defendant, of this claimant, did he have the state of mind that justified him investigating?
Yes.
So it is a low threshold. if I could sort of move on without wanting to dodge questions, but one will want to read the decision as a whole. And I think that the other sort of features of the case and the other points made again informs this central question that we're grappling with here. And just picking up just the concept of belief, this sort of enters into the analysis up to 195 and 196 is what they're saying here, is that essentially the Howard and Fawcett's line which they've looked at is just irreconcilable with the decision in DMG, and then and part of the reason for that, but they conclude at the end of 195, is that on the DMG approach, mistakes of law are treated differently from mistakes of fact for limitation purposes, and the difficult and much criticised distinction between the two remains of crucial importance. And so what they're trying to do is remove that distinction as far as they can, and then they make the point that only the Howard and Fawcett's line is consistent with the rationale. It's in the nature of litigation that facts and law are commonly disputed. It's the function of the courts to resolve those disputes. Until the court has done so, the parties can at best have only a reasonable belief that their assertions are correct. If a limitation period is to serve its purpose in fixing a time within which claims must be brought, it can only be concerned with beliefs and not with the truth. So this is the radical departure from DMG, but that is because they see DMG as having been a radical departure from the ordinary principles which apply generally in Section 32 limitation. They then in terms of belief, that if you if you got to the stage of investigating and being justified to investigate your claim, and certainly if you've got to the stage of sending out a claim to a defendant, then you have reached the stage of having the sufficiently reasonable belief. They then turn to discovery in other contexts, such as tax, the concept of discovery in tax statutes, where again there is a very low threshold by which a tax inspector has to form a view, which doesn't need to be right or wrong, that justifies him making an assessment. So these are points really throughout this. They're sort of seeking to say, well, why this is why the concept of discovery, as articulated by DMG, is wrong, and then Section 7, they deal with the point of the reality is that you don't know at the outset whether you have a claim at all. And they cite just below F, Section 32(1)(c), and they make the point that if the action runs its full course, it may transpire that there was no fraud or mistake, indeed no cause of action at all. But where at the stage of an inquiry into the defendant's plea that the action is time-barred, the claimant relies on Section 32(1)(a) or (c), the question is not whether there was in reality any fraud or mistake, that will not be established unless and until the court issues a judgment on the merits of the case. The question under section 32(1)(a) and C is whether, upon the assumption that there was a fraud or mistake, as identified by the claimant in the way he pleads his case, it was discovered or could, with reasonable diligence, have been discovered at such a time as would render the claim time barred. So in a sense, it's a backward-looking test. You know what the claimant is saying in his claim form. You know he's asserting that he's made this claim. And the question for limitation purposes is, well, when did he? When was it first reasonable for him to have begun the inquiries for that claim? So they turn to sort of reasonable diligence, really the second limb, the more objective limb of the test at paragraph 203, and they emphasise that the reasonable diligence test under section 32(1)(c) is simply whether the plaintiff could, with reasonable diligence, have done so. They make the point that the burden of proof is ordinarily on the claimant. In our grounds of appeal, we're not taking any burden of proof point on this appeal. Our grounds of appeal are that the learned judge was wrong because Jazztel discovered, or could with reasonable diligence have discovered, its mistake on the evidence found by the judge. The willing claimant attribute is considered at C on page 1437, or Justice Neuberger saying that it's inherent in section 32(1) that there must be an assumption that the claimant desires to discover whether or not there's been a fraud. Again, this is all these points there saying why DMG is wrong. These tests have nothing to do with judicial decisions. It is concerned with the steps which a person in the position of the claimant could reasonably have been expected to take before issuing a claim. They then turn to the former pre-1939 equitable rule, and one of the points that they make in relation to that is that it didn't make any difference that claimants would argue that they'd been unable to discover that they had a cause of action prior to the decision, but by some sort of court decision. That's at the very bottom of 204. It was being said that a hidden knowledge again is irrelevant, as they say. Paragraph 207. In the second sentence, that the fact that the claimant has made a mistake needs to be discoverable in the relevant sense, i.e. Preliminaries, with reasonable diligence, but he does not need to know that he is consequently entitled to bring a claim. So all your knowledge about the sort of laws of restitution or ousters and all that is not to the point. Then they turn to the practicality of the suggested approach at 209. And then they, at 209, 1 and 2 are sort of essentially making the distinction between limbs 1 and 2, reaffirming that the test of discoverability is the Howard and Fawcett's test, which they see as the same as Brown. But then the standard of reasonable diligence, this is so if you've got a person that it can't be shown that they actually discovered, then which much more likely to be the case in the FII remitter, where you've got people who paid tax under the UK's corporation tax system from 1973 to 1999, all at a time when the case law of the Court of Justice wouldn't suggest that any of that tax was the EU law, principles of EU law would come along and say that it was unlawful. So one's therefore looking at a more difficult question of at a point in time when did it emerge out of the ether that there was a possibility of a claim. But looking at that type of question, what the High Court will be no doubt doing in the FII remitter is considering how a person carrying on a business of the relevant kind would act. So, in our case, of multinationals, on the assumption that they desired to know whether or not they'd made a mistake, if they'd had adequate but not unlimited staff and resources, access to, would solicitors of the right type be advising on this type of transaction, and was motivated by a reasonable but not excessive sense of urgency. The question is not whether the claimant should have discovered the mistakes sooner, but whether he could, with reasonable diligence, have done so.
Mr. Baldry, speaking for myself, I'm not entirely sure why the test being formulated mentions, well, you've mentioned multinationals, but they certainly mention a business of the relevant kind, because the test, as I understand it, the test that's being devised is a general one under the Limitation Act.
Yes.
Now, some tax cases are like this one, and like FII, with very large sums at stake and very sophisticated taxpayers. But not all taxpayers are in that position. What about other kinds of tax situation where the same conceptual issues may arise? How then does the test work? If it's an individual taxpayer, relatively small amount of income tax that was unlawfully claimed and was paid under a mistake of law, how does it all work in such cases?
Yeah, well, I think the legal test is one of what's reasonable diligence. That's the sort of shapes the inquiry, and what the court's acknowledging, and this is probably developed further in the tort cases, that the concept of reasonable diligence is an objective test that can be applied, but it has to be applied in the context of the type of person that you're looking at. So, I can't imagine there's going to be much of that would turn on that in the context of the franked investment income GLO, which is inherently concerned with sort of multinational corporations getting sort of dividend streams. But one's judging that sort of character. That it could be a different test if you're just looking at the trader with the fish and chip shop that for one reason or another stumbles into a complicated area of law and is none the wiser for it. But in the present case, if we're looking at PLCs making share issues into clearance systems, or acquiring depository receipts, that is the sense of reasonable diligence and the resources that particular claimant can be fairly attributed to have,
Yes.
is sort of fed into the standard. So to 10, it's say in practice, the application of the approach will depend on the circumstances of the case. That's obviously so. In cases where the claimant has made a payment made on mistaken understanding of the law, which was resulted from ignorance, the mistake will normally have been discoverable immediately by seeking legal advice. Section 32(1) only has effect where the mistake could not have been discovered at the time of the payment, with the exercise of reasonable diligence.
And just pausing there, we're not dealing with an ignorance case, are we?
No.
Yeah.
In the FII case, if someone's received a foreign dividend in 1975, no one would have thought that that the tax charge was unlawful. Everyone was ignorant of what the European Court of Justice was going to do decades later.
But what the Supreme Court seems to have in mind here is a situation where actually the law is perfectly clear.
Yeah.
Someone's just made a mistake, failed to appreciate what the law is.
Yeah. Yes, and that sort of leads into the cases where there would need to be some sort of evidence, where they say that if you've got a situation where the payment was made in reliance on sort of a precedent, so you've got clear law, someone makes a payment of that, and then a subsequent court decision comes along and changes the understanding of the law, then that's a different kind of case. And the question is, well, when was it discoverable by the exercise of reasonable diligence that the payment was legally questionable? And to 11, where a payment was made in accordance with the law as it was then understood to be, the point in time at which the claimant could, with reasonable diligence, have discovered that the payment was legally questionable so as to give rise to a worthwhile claim to restitution would have to be established by evidence. The focus of that evidence is likely to be upon developments in legal understanding within the relevant category of claimants and their advisors explained above. That might include expert evidence. So that is definitely going to be the exercise on the remitter.
In FII.
In FII, CMCs are being done at the moment to go through this mammoth task of working out at what stage in the line of cases from Fakir, etc., that this sort of tipping point has been reached. But this is not. That's not
I have a nasty feeling in a few years' time we're all going to be spending a lot of time dealing with appeals on just that kind of issue.
Yes, it never ends.
Never ends.
So they have given themselves with that analysis much ammunition to criticise Deutsche Morgan Grenfell, which is what they do in the next the next section. So I won't take you all the way through that, but they affirm again the appropriate test to be applied at 213.13. So the sufficient confidence to justify embarking on the preliminaries applies both to knowledge or good constructive knowledge.
Can I ask you this, Mr. Baldry? On your submission, would a taxpayer be able to protect their position by saying, I'm paying this tax, but under protest, without prejudice to my rights?
They would be able to make that, they're certainly able to protect their position as Jazztel did, but that would not prevent the limitation period under section 32(1)(c).
I mean, if anything, it makes their position
Yeah.
worse, doesn't it?
Yeah.
I'm not quite sure how it benefits them at all.
No. Because you may have there may be another scheme available. In Jazztel's case, the 1.8 million that was paid in January 2011 was paid 2000, 11th of January 2000. That was paid with a first with a sort of payment under protest, and secondly, there was the claim was made on the 11th of January 2000. That benefited Jazztel because Jazztel was repaid that money.
Oh yes.
So the revenue, they didn't claim that until after the decision in the FTT in Vidacos, because the unusual feature of the 1999 transaction was that it involved both issues of shares to the clearance service and issue of the shares to the depository receipts holders. So when HSBC came out, Jazztel made its claim for the amounts that were issued for clearance services, and that those were the ones that are out of the revenue, so were out of time and were the subject of the appeal. The 1.8 million paid in January 2000 is of a different category because it included both issues to a clearance service and ADRs. No claim was made in respect of that until the FTT decision in the second HSBC case, which followed the CJEU case, and that said it was act clear from the reasoning in HSBC that issues of shares to an ADR is also contrary to EU law because it's a tax on an issue of a security. And at that point in time, Jazztel says, well, can we have our 1.8 million back? Revenue, yes, you've made the claim. So the odd thing about it is it appears in the judge's table as one of the payments in dispute in the appeal, but as the judge explained, that the point of that was to get compound interest.
Yes.
So we needed to establish, Jazztel needed to establish whether that payment would benefit from compound interest, because at that time Sempra prevailed. So it can be beneficial to make a claim because you've made the claim in time, but that doesn't stop your High Court limitation period running. On the contrary, we say that's crystal clear. It should stop running at that stage. And so, but generally, payments under protest, if you are saying to a defendant, well, I think I've got rights to say that this payment is mistaken, but I'm going to wait and find out. But I reserve all my rights. You are reserving all your rights, but not as to limitation.
in fact, are really walking into a bit of a trap on the limitation front.
You've acknowledged.
From one point of view, I mean, really acknowledging
Yes.
you think you've got a worthwhile claim sufficient to actually want to bring it to the attention of the revenue that you're reserving the right to pursue it.
And I was thinking, that what's the policy of a limitation period, and why should you be extending a limitation period? It runs counter to the policy.
Yeah.
So 213 really recaps what we've already seen.
Yes, and so
Yes.
that, if whenever one wants the summary of where they got to, that's there. But I'm not going to take you through it
No.
again, because I think we've covered all the points. But they certainly sort of bring in that test, and also they sort of doubly confirm their reasoning on the standard of reasonable diligence at subparagraph 16 over the page. So that's the heart of it. They then go on to discuss Claimant, Benson, and unsurprisingly, in light of everything they've said, they say that has to be departed from. So I won't take you through that section, and then they go to the application.
Just before you do,
Yes.
I've seen in the skeleton some discussion of deemed and actual mistakes, and that seems to be paragraph 229. I'm not clear how far the distinction actually matters.
No, I think that's sort of gone by the wayside. And I think that my recollection is that one of the revenue's arguments in DMG was whether 32(1)(c) should operate differently in the sort of case of a deemed mistake, in the sense of is the cut-off point, or is it an important distinction for the application of 32(1)(c) and when time runs, as to whether you've got this concept of a deemed mistake, i.e. something that was okay under law as it was, but then has judicially been changed, so it's been turned into a mistake, and really that wasn't sort of picked up. They sort of dealt with it more fundamentally.
Yep.
They
Okay.
talk.
So 254 you were taking us to.
Yes, 254. Just they turn to, well, now we've reached this decision. In this case, what do we do? And I think we've already touched on these points. They say that the court in that case cannot determine in abstract the point in time when the test claimants could with reasonable diligence have discovered to the standard of knowing that they had a worthwhile claim. The evidence there is going to turn on EU law in relation to tax regimes which discriminated between companies based in one member state, companies based in another, developed through a series of judgments of the Court of Justice, including Verkuium, 2000, Lentz, 2004, Manninen, 2005, Hurst, the DMG GLO case in 2012. Each of those judgments was itself the result of a claim made some years earlier. In Hurst, for example, the claim was filed in 1995, 11 years before the judgment of the Court of Justice. DMG was aware of the claim almost immediately, and it was for that reason that in
When you say 11 years before the judgment of the Court of Justice, I thought Hurst was 2001.
It's yes.
Maybe they're referring to some other judgment.
They might be referring to the first FII reference.
Yes.
Yes.
Yes, I think that may be right.
Yeah.
But in any event, I couldn't help notice that the claim in Hurst was filed in 1995. This is right, is it? That here we still are, sort of feeling the ramifications of all of this.
Yes,
many decades later.
Lord Walker, I think, was the thunderbolt from Luxembourg.
Yeah. My recollection may be faulty, but I think I was junior counsel in Herxt.
Yeah,
I do remember the claim in 1995.
yes, I can see it's not the kind of fact pattern that necessarily sticks in the mind, but yes, they have been running a long time, and yeah, that from the sort of the position where we arrived at once, where there was compound interest going back to 1973, a no limitation period. There has been a period of adjustment since then. Yes, and still to be talking about now we've left the EU. Maybe we'll still be talking about it when we rejoin.
That would be nice.
So then at the bottom of 255, of course, DMG was aware of the claim almost immediately, and it's for that reason that in Deutsche Morgan Grenfell, Lord Brown considered that time began running for DMG in July 1995. So at the time when if Hirsch knew about it, then it must be reasonable to suppose that DMG can be supposed to have known about it. And they say,
when you say reasonable to suppose, I mean DMG was aware of the claim.
Yes, and therefore could, with reasonable diligence, have discovered its own mistake.
Yeah.
But he goes on. They go on to say, but the date when the claimant became aware of another claim and appreciated its potential implications for its own situation is not conclusive if a claimant acting with reasonable diligence could have discovered that a worthwhile claim at an earlier time. Equally, the answer to the question arising under Section 32(1) does not depend on the characteristics of the particular claimant, whether, for example, it was inclined to await further developments and to allow other taxpayers to make the running. The standard is could. So I think everyone accepts that the mere fact of another claimant making the claim is not conclusive, but certainly it's part of the evidence as to when somebody could, with reasonable diligence, have discovered that fact. So that's why we would say that if, in this case, Jazztel did discover its mistake as early as 2000, as we say it did on the test to be applied, then that is going to be relevant for the other claimants in the GLO. That takes us to the close of the majority reasoning in FII, and I wasn't going to take you to the minority. But turning to Jazztel, the mistake which Jazztel is asserting in its particulars of claim is that the statutory provisions of the Finance Act 1986, which required SDRT to be paid, the mistake was that they thought that was lawful, and the ordinary limitation for a claim for payment by mistake is 6 years. But yes, Jazztel can extend that limitation under Section 32(1)(c) until the date they discovered, or could with reasonable diligence have discovered, that the provisions were unlawful, and the test to be applied is that time runs from the point in time when Jazztel knew, formed the belief, or could with reasonable diligence have known or believed that it had made the mistakes which it asserts it made with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the defendant, taking advice and collecting evidence. And we say that the evidence in this case, the facts found by the judge, show beyond a doubt that Jazztel knew of its mistake with the requisite degree of confidence by the latest on 11th of January 2000, by which time it had obtained advice that the statutory provisions were vulnerable to challenge under EU law, and had accordingly submitted a claim for repayment of the tax they had paid on the 7th of January of the 1.8 million. And so we say that Jazztel knew of its mistake under a proper application of the test, and it inevitably follows that it also discovered, could with reasonable diligence have discovered that mistake if one looks at it objectively. We've set out the detailed evidence on which we rely at paragraph 44 of our skeleton. So we've cited there the relevant passages, but it might be helpful to take you briefly through the judgment just to show you where they appear. So go to the core bundle. Tab 9. So if we pick it up at page 1119, this was in the context of the share issue taking place in December 1999. Linklaters wrote to Jazztel on the 22nd of December, and at the penultimate paragraph on 119, they say that there are good arguments that the operation of SDRT in some circumstances is against European law, particularly that relating to the freedom of goods.
Just pausing there, that wasn't the ultimate problem with the legislation, was it?
No. At the outset, the claim to the revenue was based on both the Capital Duties Directive, saying it's a breach of the Capital Duties Directive, but also the treaty freedoms, and that argument was pursued. Both arguments were pursued up to the HSBC Court of Justice decision. It was the Court of Justice that said, well, look, you have a specific directive on this provision. It's the directive which is to be applied, and therefore we don't need to look at the treaty provisions. But certainly, by the time Jazztel was making its claim, it was well understood that the Capital Duties Directive was one of the reasons why.
And indeed, when you come on paragraph 49, there's reference to the Capital
Yes.
Duties Directive as well as
Yeah.
the freedoms.
Just on 119, that
Yes.
in the context of Project Saxo, we think the arguments are weak in relation to the SDRT payable on transfers by existing shareholders. So one can see there that there was the express allowance for transfers under Article 12 of the directive, and on the issue of ADRs, and stronger in relation to the issue of new shares into Euroclear. So there's a range of different advices. In fact, all the claims which are in issue now, I understand, are all clearance service shares. But as I said, the 1.8 million payment contained a mixture of both. And so, in relation to the stronger, in relation to issue of shares into a clearance service, the position is not free from doubt. But any attack on the duty would be very strongly resisted by the UK Inland Revenue, as this would have wide implications for stamp duty generally, which brings in significant revenue for the government. In view of the fact that the duty is likely to be payable on the shares issued in ADR form in any event, we're looking at an amount of 700,000 at stake. There must be doubts about whether this is worth pursuing in the case of Project Saxo, but this is one for the company to decide. Then they explain the reasoning in more detail, paragraph 49. In the accompanying SDRT advice, which is cited by the judge at paragraph 49. So there appear to be the sort of paragraph beginning, as you are aware, halfway down that we summarise the grounds for the possible invalidity of these charges. It may be, however, that as a practical matter, and having regard to the sums of money involved, which Jazztel is liable, and the length of and complexity of any potential litigation that would be required to successfully challenge the charges, you may well conclude that it would not be worthwhile taking the matter any further, and the prudent action is simply to pay the 1.5 SDRT charge, and then they set out the grounds, including little c, the provisions of Article 11 of Council Directive 69/335, prohibiting member states from subjecting any form of taxation whatsoever the creation, issue of shares and securities.
So when that, Mr. Baldry, when that uses the phrase worthwhile, I think you submit that that's clearly using it not in the legal sense,
Yes.
but in the sort of practical commercial sense.
Yes. Yeah. Yeah. And so they look over the page at 121. Well, there's a range of circumstances.
Can you just
Yes.
talk us through those first two full paragraphs? Which situation were we dealing with, or was Jazztel dealing with, in terms of the scenarios set out at the top of 121?
I think whether in the context of the UK incorporated company, I think what they're saying there is in a share-for-share exchange, where the shares are in the target company are held within a EU clearance service, that was what they thought was the strongest case completely. We didn't have a share-for-share exchange.
Yeah.
Ours was simply an issue of shares into the clearance service. So that was very strong grounds. And then, so below, whilst the grounds for questioning the validity of the 1.5% charges arising on the issue and transfer of shares into a clearance service referred to above remain, they become less clear-cut. So,
And that's the scenario that Jazztel was dealing
yes.
with.
And then balanced against that, as one would expect, the difficulties were set out. The note goes on to say, you should be aware that any attack on the 1.5% SDRT charge on the issue of shares into a clearance service could fundamentally undermine the SDR regime. It is almost certain, therefore, that any attack on this charge would lead to strenuous opposition from the Inland Revenue that would be most likely to result in litigation that would not be decided without referral to the European Court of Justice. This would obviously require lengthy and expensive litigation with no guarantee of success, or that the existing charge would not be replaced by an equivalent but valid tax. On this basis, we would consider there are two options available to Jazztel in relation to the 1.5% charge arising on the issue of their new shares, to pay the charge on the basis that it's not large in the context of the funds raised by the issue as a whole, and that the time and expense that is likely to be involved in challenging it does not in practice make any challenge against such shares feasible or desirable, or two, to pay the charge, but with the lodgement of some sort of protective claim, stating the grounds under which it is considered that the charge is invalid, and as a result of which it may be possible to reclaim the SDRT paid if a successful challenge were mounted against such charge in the future.
That may be quite interesting, that second option, because earlier I suggested that a taxpayer might try to protect their position by simply saying, I pay this tax, but under protest. But actually, what this is advising is something, do a bit more than that. Is that right? That you issue a claim, but make it a protective one. So, have I understood?
Well,
that?
I think certainly if you went so far as issuing a sort of claim in the High Court, that would be a protective claim. But what they had in mind here was, I think what happened,
The statutory one.
a more informal claim outside the scope of the High Court.
Yes.
You don't issue a writ. And there may be reasons for, at that time, not issuing a writ. It's a matter of law. I mean,
Yes.
they may have felt at that time that the provisions, their rights to restitution were insufficiently certain. But that's irrelevant. The question is, are they thinking about the potential mistake that they made? So as far as, yes, so you may consider that the amount of money that is likely to be open to challenge, so it's a sort of a cost-benefit analysis is applied. The amount that you've got here, it may not be appropriate for you to take the claim forward. But that's just sensible advice to someone who has a potential claim. And as far as over the page, looking at B, the protective claim, they said in order to be in a position to lodge a considered case for questioning the validity of the charge, it would be necessary for us to undertake a detailed analysis of the position under EU law and of the structure of the clearance systems involved, and probably seek counsel's advice on the question of the validity of the charge. We do know that Linklaters investigated the position carefully, because they wrote a more detailed analysis which they put to the revenue. There's no evidence of counsel's advice being taken, but I don't think that makes any a difference. And they say that in addition, since the party technically liable for the SDRT on the issue of your shares into Euroclear is Euroclear, it would be necessary to involve them closely in any attempt to attack the validity of the charge. So we don't know whether the letter was cleared with the other parties, but we assume it was. So that was the sort of the potential strategies that were explained to Jazztel, and on the 7th of.
And that just before you go on to the 7th of January, the paragraph that follows the as stated above bit, that isn't relevant.
Yes, the existing, there was at the same part of this transaction, some of the existing shareholders were required to transfer their shares.
But that's not the basis of
No.
anything that we're concerned
That's
with now.
that's still lawful.
Yes.
No one knows. But yeah. Yes, I mean what the directive says is member states cannot tax issues of shares. Member states can tax transfers of shares.
Yes.
And therefore, Linklaters send the revenue, the cheque for the 1.8 million, and at the same time, so that's they write to the stamp office, and at the same time, we enclose a letter seeking confirmation of the correct SDR treatment for the transaction from Mr. Halsey at the stamp office. You should note, however, that since the earlier correspondence, it's occurred to us that the UK SDRT provisions and related regulations that purport to apply in this case are very probably inapplicable under European law. We are accordingly writing to Mr. Halsey regarding these issues, and will forward you a copy of our letter to Mr. Halsey for your information as soon as we can. Accordingly, you should understand the purpose of our payment today is merely to avoid any interest or penalties if, notwithstanding our view on the European law issues, these SDRT charges were ultimately found to be applicable. Payment, therefore, does not involve any admission by our client that the charges are applicable, is made without prejudice to their rights under European law, which they specifically and fully reserve. So that's payment on the 7th of January 2000, and then the communication to the stamp office is referred to at paragraph 52 on 11th of January. Linklaters set out in that letter a summary of their reasoning as to why the charges and stamp duty referred to are unlawful, and say that we've, as you see for the enclosed copies of the letters to Worthing and stamp offices, payments have been made to essentially protection. Accordingly, we would request that you instruct the stamp offices in Worthing and London to return to us the money paid to them relating to the issue and the transfers, if you agree with our analysis set out above, so that we may remit such sums to our client. The revenue disagreed with that, and you've seen from the judgment. Linklaters then respond to the revenue, say, well, we were not convinced by your arguments. We're reverting on our clients on this matter, and we'll contact you in due course if and when we have instructions to do so. And the outcome of the further discussions was that our client is not at present proceeding with this matter any further. That's on top of page 124, and we've seen from the correspondence all the practical reasons which were being put to Jazztel as to why it may not be in their overall interest to consider proceeding with the matter any further. And the judge calls that the end of sort of period 2, and that was the period where the discussions had taken place as to the vulnerability of the charges under EU law, and the pattern that thereafter development was as set out by the judge was that the Jazztel didn't send a repeat of that letter every time it made the payment, but it continued with payments typically under protest.
So the letter that they're repeating is that we get quoted in paragraph 50.
Yes.
Essentially, or something to that effect.
Can I just clarify which letter you're referring to in the...
Yeah, sorry. You say that when Jazztel made payments in the future, they sent a letter to equivalent effect. To equivalent effect of that quoted by the judge in paragraph 50.
Yes. No.
I have to say, at points it might be easier if we looked at the original documents, but if we're tying ourselves to the judgment, what has the judge said?
I want to interrupt there. If my lord looks at the top of page 125.
It wouldn't be easy, Mr. Krasinski, if we looked at the documents.
I'm not suggesting you shouldn't.
No.
I don't want to be difficult, and if my lord wants to look at it, you should look at it. But I'm just showing you the bit of the judgment at the top of 125.
No reservation.
No reservation, and the same at the bottom of 125, just above Roman numeral 6.
Yes.
Yes.
Yes. I'm grateful for no defence. So for those payments, there was no reservation, but the reservation of rights appeared in some of the later transactions, which the learned judge.
So are we jumping forward a few years? I can see 27th of February 2007, page 126.
My lord, that's a typo. It's 2006.
It's 2006.
Yeah. Yes. Yes.
So is that the next reservation?
Yes.
I'm so sorry, where was the typo?
In Roman numeral 8.
8, oh thank you, on
126.
page 126. That should say.
And I don't want to interrupt Nathan anymore,
Yeah.
but the corresponding document for that one, which is why you know it's a typo, is
So shall we just look at it?
Yes.
unagreed bundle tab 100.
Yeah.
Yes. If I can. Perhaps it may be easier to. I don't know if you're going to use the larger bundle.
I'm sure it's safer to use the larger bundle.
If we go to the larger bundle, I'll just very briefly show you the documents that we've just been quoting from, so you know where they are. The 7th of January letter is referred to the judgment in paragraph 50 is tab 29 of the two volume. So this is the letter by which the payment is sent to the revenue. We're at the Jazztel instructing that that's what the learned judge quotes. And then
So there are two letters, are there, to similar effect? Because tab 30 has the same
Yes, that is to the letter on 165
I see.
is a letter to the Worthing office. So it looks like that's where the money goes.
That's accompanied by the cheque, which you see at page 167.
Yes.
Yeah.
And then the letter at tab 30 is to the more sort of formal.
Is it? It says this is for acting for shareholders. The previous one was acting for Jazztel.
Oh yes, yes, you're quite right. So we're instructed to send a cheque for the 2.8, which arrive on the transfers. Yeah.
Yes, that's it.
So existing shareholders make transfers.
So that one isn't the subject to any dispute.
No. That letter seems to was sent a copy of the directive was sent. I don't think we've actually looked at that yet, but it's there. Article 11 is on 177, and Article 12 on 177. Then at tab 33, the 11th of January letter, which is quoted by the judge at paragraph 5,
52.
paragraph 52. So this is the letter by which the revenue seek repayment, and just there was discussed the earlier, what the judge doesn't sort of recite the detailed arguments that were put to the Stamp Office, but you'll see that the way it progressed is, well, we'll need to put in we could put in a protective claim. If we do that, we'll need to look more closely at the provisions, and so that's what's been done here. And what this letter is doing is articulating the mistake which is being asserted that Jazztel now made. It's articulating the basis on which the domestic provisions are alleged to be unlawful. So, bottom of page 183, it's said that we consider there are very good grounds for the view that the provisions of sections 96, 93, 70 and 67 FA 1986 are inapplicable under EU law. Our views are based on the provisions in and now directive after their more sort of considered look at it. Directive 69 is placed at the forefront. The Capital Duties Directive and Articles 56 and 49 of the Treaty of Rome. That's restrictions on the movement of capital, Article 56, and restrictions on freedom to provide services, Article 49. They explain how the SDRT charges arise, and then they explain their summary of the reasoning behind their view that the charges to SDRT and stamp duty should be considered to be inapplicable under the relevant provisions of EU law. And they go through the process saying first the directive has direct effect in this situation. They refer to Article 11 that contains the prohibition on taxing issues of securities. And the charge of SDRT, they say, clearly imposes taxation on the issue of shares by a UK incorporated company.
That argument at 184, just under the heading 1.1, the issue, where they refer to Article 11 of the directive, is that, in essence, the argument which ultimately prevailed?
Yes, yes.
So here we have a letter from them saying, on the 11th of January 2000, we consider there are very good grounds for making that submission.
Yes. And
indeed asking for repayment. I mean, it's a letter of claim, isn't it?
yeah.
As I understand it, Mr. Baldry, your submission to us now is that if, when you were arguing this case at first instance, you'd had the benefit of what the Supreme Court eventually decided in FII, in other words, Deutsche Morgan Grenfell was wrong, you would have had a very good argument to say, just on the basis of this correspondence, you don't need any more evidence, you satisfy the objective test, which is the law.
Yes.
That's really what you're inviting us
Yes.
to hold, is it?
Exactly. And I say, there can't be evidence to say that this letter wasn't sent, this correspondence wasn't entered into. It's uncontrovertible, and so the question for this court to decide is whether it meets the threshold of the test that's been articulated in FII, and we say it does.
Revenue said not likely. So that's tab 40, is it?
Tab 40. I was still
Sorry, yes.
just completing the claim letter. So the summary is that since Article 11 has direct effect, this is second paragraph of 185, its provisions can be relied on by residents of the EU and can be enforced by domestic courts. Again, all correct. The provisions of 96 and 93 have been introduced after the date on which the directive came into force. They then turn to the Treaty of Rome provisions, which were also potential challenges to the legislation, but as I explained, on that point the HSBC decision confirmed that because it fell within the scope of the directive, it was the directive that was to be applied. So to that extent these arguments fell away, and on the basis of having articulated that argument and having articulated the basis on which it's being asserted that the domestic provisions were unlawful, the request for a repayment was made.
And the revenue said, we don't agree.
The revenue said, I don't
And
agree.
they say, this I think you said was the argument that was ultimately pursued before the Court of Justice, Article 12 applies.
Yes, essentially their season ticket argument. Well, it may say on the face of the legislation that it's unlawful, but we will be sort of contending for a purposive interpretation of the statute to say that it really falls in as part of the transfers. It's a tax on. It's really a tax on transfer, not a tax on issue. The court says no, it's a tax on issue.
But in relation to the Limitation Act point, as I understand it, your essential submission is whoever was right or wrong, the issue had clearly been joined. in the correspondence in January through to March 2000.
Yeah.
And then they've got a choice. They could have claimed. They decided not to claim at that time.
Yes.
But then if they don't claim, I'm not saying you're right, but you say that in those circumstances they can't complain afterwards and say, well, hang on, limitation hasn't been running against us.
Yeah. I mean, as a practical decision, you get the advice, and your choice is: do I want to take this claim for 1.8 million to the revenue, to the courts, to the European Court of Justice? No, I'll put in a protective claim so far as I can, and another taxpayer might do. Indeed, they did. HSBC, who also paid SDRT in 2000, but paid on a much bigger transaction, 20 million or 28 million pounds worth. They may have got the same advice, they may have got different advice. They took their claim forward. But and also the fact that Jazztel was able to not simply begin investigations, but to articulate precisely the very mistake that the Court of Justice effectively came into existence, or the basis of the mistake, the unlawfulness. So thereafter, nothing else changed. So that, having reached that state of awareness of the lawfulness of the provisions in 2000, there can be no basis for saying that a Jazztel state of knowledge was of any lesser degree for the subsequent payments were made, and it's true that over a couple of periods that payments were made without express reservation of position, but subsequently reservation of position was made. We say that's...
So just as to that, it's right, is it, that there was no further reference to this on the Jazztel side until, is it tab 100 in the second volume? Or is there something in between?
No, I think most of the intervening pages are Jazztel insertions, so I don't think there's anything that we would say.
And just so I understand the picture, if we go back to the judge's summary in paragraph, well, on page 107 of the bundle of the payments.
Yeah.
This table. So the biggest payment was that on the 7th of January 2000.
Yes, there was another significant payment, 27th July 2006. Those were.
So just pausing there, 7th of January 2000, 1.8 million. Linked data is more optimistic about 700,000 than they are about the other 1.2 or 1.1. Then we get another 393,000 in August. Then we jump through to 2004, really, do we? For a large payment. November 2004, we get 500,000.
Yes.
And 2005, we get 142,000. 2006, if you aggregate the three payments, that must be getting on for 2 million.
Yes.
Yeah. But of course, we can't tell how far this would be affected by the ADR point, which Linklaters hadn't been so optimistic about.
No. So the yes, I think that's sort of the critical part of the evidence. Set out the rest of it in our skeleton. I haven't taken you through all the documents in that we handed up, but we say I think I've read the ones that we think the court should certainly.
Sorry, the
read.
documents you handed up.
In the unagreed bundle.
In your
which we've,
unagreed
yes,
supplementary bundle,
which
yes.
We've read the ones that
Yes.
I really wanted the court to read to understand that pattern anyway. The other documents are there. So they fall into three categories. And what I've prepared is as a short sort of note. Mr. Wilmot Smith prepared a note setting out what category of documents there are, because there are documents that the judge has actually quoted from that we've been looking at. There are some documents which the judge refers to, sort of, but does specifically, but doesn't actually quote. And then there are sort of generic documents, such as there's a reservation of rights documents which the judge doesn't refer to, but we've included them just to provide the full picture. And what this note does is just specify which category that they fall into.
And Mr. Kosinski, are you content we should have this?
I'm not. I'm objecting.
Yes. Thank you very much.
Contentment is a different state of mind.
Thank you.
Thank you very much.
But I'm not relying on those documents
No.
for facts outside the scope of the judgment. And since they provide that sort of background, we thought it would be helpful for the court to have them. But unless the court wants me to guide through more specifically, then I was proposing not to take you formally through them.
Can I, Mr. Baldry, just mention what is, speaking for myself only, causing me some concern about this line of submission. After summarising the correspondence that you've shown us, on one view it could be said that the judge makes certain findings of fact. If you look at pages 129 to 131, particularly paragraph 67, he makes a finding, well, it looks like a finding of fact about Jazztel's predominant state of mind after it had received the 22nd of December advice. I won't read all of this out because you're very familiar with all of this, but he mentions the two options which had been suggested by Linklaters in the first half of page 130. And he says, in the event Jazztel actually followed neither course, but took a middle way, made payment with a reservation of rights. And then he says at sub 4, in these circumstances, there are two possibilities. And he concludes at the bottom of page 130, whilst I consider that Jazztel must have had some doubt as to whether the tax was lawfully due, my conclusion is that this doubt was a marginal one, and that Jazztel's state of mind was predominantly, as it had been prior to the advice, namely that the tax was due. As I said, I'm not going to read all of this. You're very familiar with it. But essentially what I'm getting at is that aren't these findings of fact? And they may be right or wrong, but how can we interfere with them?
What I would say on that, my lord, is that there is no inconsistency between Jazztel being mistaken and it having reached the stage for limitation purposes of that mistake being discoverable. So if a claimant is advised by their lawyers, they think, well, is this tax charge unlawful? And they're advised by their lawyers, well, yes, it may well be. It's worth a claim. And they go and think, well, I can see it may be worth a claim, but here's the law. I'm going to take the law as being as it stands. So I'm going to take the view that the provisions are lawful. So I make my payment. Now, as a matter of the law of mistake, that may be a mistaken payment, but the limitation test is serving a different policy, and it's a different test, and it prevents that claimant not having to bring its claim within the ordinary period if they've got to the stage of considering that they can articulate what the mistake, if it does exist, would be. That was the sort of retrospective aspect to the mistake. One assumes that the law is as the claimant is now asserting it to be, and is asking, well, did they get to the stage of working out what that would be? So it is on first blush, you say, well, this is odd. We're saying he's discovered the mistake, and then the judge says there is a mistake. But in my submission, there is no mismatch there, because the two concepts are different, and the limitation concept is different. And I think you might have seen that Lord Brown in DMG went so far as to saying, well, once you've reached the point of discovering your mistake, any payments thereafter shouldn't be regarded as payments under a mistake.
I mean, he thought limitation and mistake went together, really.
Yes, but in my submission that now that we have got this test that's been articulated in relation to a mistake, then if you satisfy the discoverability, then it may be that you have made you then make the same payment under the same state of awareness in the future, such that you may think, well, I'm until the law is clarified, I take the view that I've got to abide by the law. I think these charges are lawful until it's shown to me otherwise. So I then pay by mistake, but I've articulated why I think.
I mean, we can see the test the judge was applying, I think, from 30 subparagraph 2, where he explains that mistakes can coexist with an element of doubt.
Yes.
It seems to me at the moment, I mean, you're stuck with the judge's findings of fact about the subjective state of mind of Jazztel.
We haven't challenged.
And you haven't challenged those, and there are well-known difficulties in challenging findings of fact by a trial judge. So you have to take that on the chin, as it were. But as I understand it, your point is really that the limitation question is a different one, and in particular, it has the objective second limb as to when, with reasonable diligence, the mistake could have been discovered. And from that point of view, it's not relevant, or at least it's by no means decisive, what Jazztel's subjective state of mind was. And if you look at the correspondence, I mean, it speaks for itself. Any reasonable person in receipt of that correspondence, and with that advice from its very expensive city solicitors, couldn't really have been under any objective doubt.
Well, yes.
Well, and that's, as I say, that is really what you're saying. I'm not necessarily saying I necessarily accept that.
That is what I'm saying. Yes, but the way your lordship puts it, that there are these two different policy
Mm.
concerns which the two branches of the law are dealing with, means that there shouldn't be a great nothing going wrong by the discoverability of the mistake taking place at the same time as a payment being made by a person who takes the law as it stands.
So that, as my lord has said, there are the two questions. There's the objective question and the subjective question. The objective question you've just been talking about. In terms of the subjective question, maybe it sort of harks back to my 40%, because the judge says that the advice must have injected an element of doubt. The monolithic state of Jazztel's belief came to be qualified, but then he concludes that while Jazztel must have had some doubt, his conclusion is that the doubt was a marginal one and that Jazztel's state of mind was predominantly as it had been. So, supposing, looking at the subjective aspect, that Jazztel thought, certainly probably, that the tax was due, but it had a marginal doubt, would that get you home on a subjective basis? I mean, it must, on that hypothesis, have thought the doubt was less than 50%.
Yes, but I think what I would say is yes, it does get me home. Once you've got to the stage of being in a position to articulate what the mistake you subsequently assert is, or investigate into that fact that you subsequently assert is a mistake, then you have got to the requisite stage. Now that you may be very confident about your view of the law, or you may be unconfident about your view of the law. But if you recognised that there is a potential unlawfulness that is worth looking at, then for limitation purposes, that's when it stops. And so in this case, because it was recognised in the 2000 payment, then that sort of franks all the other payments.
Amongst the various formulations in the Supreme Court, we get legally questionable such that you've got a worthwhile claim. Now, if your predominant view is, well, I've got to pay, but I have a marginal doubt, do you think it's legally questionable such that it's worthwhile to make a claim?
Yes, it was, because they did. It was put to them. Do you want to do? You can pay, or you can make a protective claim.
Which is what they did. They made a claim. We've seen it on the correspondence saying, please pay it back.
You will need to incur. We'll need to go away and do some work and possibly consult counsel on this. And they did. We didn't see what it cost them, but they subsequently made the claim, which articulated in much more detail than ever before, because it was right, what the mistake was. So yes, once you got to that stage, you're way beyond the test.
Well, I don't think there's any evidence we've seen that counsel were consulted.
No,
I'm
sorry,
I'm not sure what you were suggesting.
No,
so I don't think
sorry,
that was.
I did not mean to suggest.
I'm sure you didn't mean to. It sounded as though you might.
It was in the letter.
Yeah.
My point was that they instructed Linklaters to write that letter. You have the option. You can do nothing, or you can make a claim.
Well, that's right. But the more important letter is the following one, isn't it? The actual letter of claim
Yes.
that we've been taking us through. I mean, there it is in black and white, saying.
But they're not just airing some kind of theoretical academic point that might be made. They're actually saying, for these legal reasons, you must repay.
Yeah. For exactly the same legal reasons which they are now asserting in these proceedings, but they are mistaken about.
Yeah. Is this right, Mr. Baldry, that under the Limitation Act point, you don't need to win both under the subjective and the objective limbs? You only need to win under one of them. And although you don't abandon the subjective one, I think you emphasise more the objective.
Well, I put them both.
Yeah, I know you
so
do, but you don't need to win
No,
on
I
both.
don't.
If you win, if
Yeah.
you win, and I'm not saying you will, but if you win on the objective one, that's enough for your purpose.
It is, yes. Well, I think I've covered. I've covered the points. I think you have the revenues case. So just to summarise, we started this case, and the judgment below was all about Section 320. My primary submission on Section 320, as you heard, was that whatever the application of Section 32(1)(c in the particular facts of this case is, that even if there was a longer period under Section 32(1)(c available to Jazztel, which was curtailed by Section 320, our primary submission is that nevertheless, in the circumstances of this case, Section 320 is applicable, and therefore that Section 32(1)(c is disapplied. And that remains our primary case. If you were to accept that submission, then it is possible that you would not need to address Section 32(1)(c as an issue, subject to the point that you would want to not make the same assumption that the learned judge made, that there was an extended limitation period. But we wouldn't need to finally make a conclusion on Section 32(1)(c. But certainly if you do not accept the revenue submissions on Section 320, then we very much rely on Section 32(1)(c, say that even if Section 320 is unlawful, because my learned friend from Persuade You, it doesn't matter what the circumstances are, it's just Fleming says that you've got to strike a blue pencil through it, then we would say, well, let's look at Section 32(1)(c. The learned judge has decided this case on the basis that they had an extended limitation period, but in the light of the law as it now stands, dramatically changed, the position is different.
Yeah.
So, unless I can assist you further, those are the revenues.
So you've got the request for ICI and Liberty.
Yes. Lord Justice Singh is mentioning the authorities that we raised this morning. Presumably it hasn't yet been possible to produce copies of all these things, so it has.
We have.
You probably haven't had a chance to look at them yourself anyway.
No, I mean, I would be content to deal with it in a reply.
Can I just check, Mr. Because there were actually two requests. I think you've mentioned one of them this morning, but I wanted to check that you got the second one. There's a reference to cases called ICI and Liberty.
That's the request that I've got.
Oh, I see.
I'm not sure
Oh, right.
what the first
Now,
request.
you mentioned, I think it was Hayward Estates.
The requests that I'm conscious of are ICI and Colma, National Council for Civil Liberties and the Home Secretary, Deutsche Morgan Grenfell itself, Hayward itself, and I think this is we also sent through to you, didn't we, the 1974 interim report of the Law
Yes.
Reform
Yeah,
Committee.
I have all that. Yes.
In the sense that the phrase worthwhile cause of action had obviously featured in earlier case law, and then the Law Reform Committee addressed its mind to that in some sense, but I can't claim to have read it So I'm not exactly sure what the upshot was.
Yeah. Well, certainly, I mean, I've got to the stage I have got. I mean, I will have you know, this evening to read through those cases, and I'm minded to say that the simplest way to approach this would be to deal with them in response to.
Yes.
And then the friend has to.
Would it help if I draw attention to specific passages? Because they're very long judgment. Well, the Liberty one is a very long judgment.
That would be extremely.
Yeah. In ICI, I think it's page. Can you just remind me where it begins? What's the start page?
2035.
Yeah, it's page 2041 that you may need to look at. And in the Liberty case, it's paragraphs 58 to 69.
Thank you. Oh, and the one other point is the AB
Oh, yes.
case,
Yes.
which we also have copies. So we do have copies of. Yes.
Right.
So
I mean, assuming Mr. Krasinski is content, rather than asking you to go off now and look at these cases and make any comments you have at this stage in your submissions, it seems more convenient for Mr. Krasinski to get going. If any potential injustice to either side arises out of either of you not having had a previous opportunity to deal with the cases, then we can address that at the time. You're content with that, Mr. Krasinski? Good. Yes. In which case, unless anybody has anything else, thank you very much, Mr. Baldry. Mr. Krasinski.
I'm going to follow the same structure as my learned friends. I'm going to start with the Section 320 issue. I'll then deal with the application for permission to advance the new Section 32 defence, and then I'll turn to the substance of that. Can I start under the heading of Section 320 with identifying some common ground? First, that the SDRT payments made by Jazztel were all paid in accordance with domestic legislation, specifically sections 93 and 96 of the Finance Act of 86, which has since been found by the Court of Justice in the HSBC litigation to have been contrary to EU law, specifically Article 11 of the Capital Duties Directive. Second, that Jazztel had the right, commonly known as San Giorgio right, to recover the sums of tax paid contrary to EU law, and that one of the causes of action available to vindicate that right was the Claimant restitution claim for monies paid under a mistake of law. Third, that each of the payments was in fact made by Jazztel operating under a mistake of law, namely their belief that the sums were lawfully due under sections 93 and 96, and that those provisions were valid. As we've just seen, the judge rejected the Crown's factual case that because of the Linklater's advice, Jazztel had a good argument under EU law and was therefore not operating under any mistake. I'll take you in due course to the pleadings. So again, it is common ground that the revenue's only potentially available defence to repayment of the sums is under the Limitation Act. And finally, it is common ground that for payments made more than 6 years before 8th of September 2003, that being the date of the Paymaster General's announcement. So in other words, for payments made before 8th of September 1997, which were thus immediately out of time once Section 320 came into effect, that provision, Section 320, is contrary to EU law and must be disapplied. That is the class of case which has been described as disappearing in a puff of smoke on the 8th of September 2003. And I say that's common ground just to highlight that. My lords, turn to the defence at Core Bundle tab 13. Paragraph 26.2, which is at page 205 of the bundle. This is the revenue defence at 26.2. Further, and in any event, even if a claim for mistake can be made out, well, perhaps I ought to give that some context. If you turn to the previous page, 24.1, it is denied that the claimant was mistaken in any respect, as Linklater's letter made clear. The claimant, from the very first payment of SDRT, believed that the SDRT was not payable on the basis of the legislation contravening EU law, and that was rejected. And then going back to 26.2, even if a claim for mistake can be made out, any claim for relief, to the extent that it relates to a payment to HMRC prior to the 19th of December 2007, is time barred by virtue of changes made to Section 32 of the Limitation Act. And then these rather Delphic words, save to the extent that Section 320 operated unlawfully to curtail the claimant's right under EU law, what might be called hedging one's bets. So with that in mind, we made a request for further information on the Part T CPR, and the response to that can be found in the supplementary bundle at tab 3. Page 11. Bottom of the page, under paragraph 26.2, question number 3, to what extent is it admitted that Section 320 operated unlawfully to curtail the claimant's rights under EU law? Answer, it is admitted that Section 320 operated unlawfully to the extent it curtailed completely, as at the 8th of September 2003, the claimant's right to claim repayment of SDRT paid before 8th of September 97 and claimed more than 6 years after the date of payment. That's the puff of smoke category. So that is the common ground. The key question in this appeal are whether Section 320 is likewise contrary to the EU law principles of effectiveness and legal certainty, insofar as it affects all claimants who had accrued rights at the time Section 320 came into effect. In particular, therefore, all those who had made payments of SDRT between September 1997 and September 2003. And whether, as a consequence, the court should disapply that provision for all such claimants, or whether, as Mr. Baldry contends, the disapplication should only be for a subset of such claimants, judged by reference to what his skeleton argument calls an inherent transitional period. My lords, in our submission, the answer to that question is given unambiguously by the House of Lords decision in Fleming. I'm going to turn to the passages in a minute, but I want to articulate at the outset what we say is the binding ratio of the decision in Fleming. And I'm going to read it, therefore, as slowly as my lords wish me to. It is as follows. Where Parliament has enacted a new time limit or has shortened an existing time limit, and that new limit affects persons with accrued rights, then, in order to comply...
Hang on. I'm not sure you can see the judge's pen.
I can't.
Yes, in order to comply
With the EU law principles of effectiveness and legal certainty, the legislation itself must contain an adequate prospective transitional period. Further, and this is still within what I say is the binding ratio of Fleming, if the legislation fails to include any transitional period, the proper remedy is for the court to disapply the new time limit for all persons with rights which have already accrued at the date the new time limit takes effect. Last sentence. The court cannot fashion a remedy which entails deciding what a reasonable transitional period would have been if one had been enacted by Parliament, and then not disapplying the new limitation period, where, on the facts of a particular case, the claim was commenced outside of that period. That's a rather long expression of the ratio, but it is, in my respectful submission, the correct ratio. Mr. Baldry has already helpfully taken you to the judgments of the Court of Justice in Marks and Spencer and Grundig. And for the time being, I'm not going to go back to them. I think, with respect, it is more helpful if I go straight to Fleming, because each of their lordships in Fleming considered very carefully what principles should be derived from the Court of Justice's decisions in M&S and Grundig.
Just before you do that, Mr. Grudzinski, can I ask you two questions?
Yes.
The first is, do you accept that if Parliament does enact a transitional period, then it does become a matter for the report to evaluate whether that transitional period is a reasonable one?
Yes.
And secondly, do you submit that in enacting the new limitation legislation, Parliament has to stamp it expressly, this is a transitional period?
Yes. So Fleming is at Authorities Bundle tab 2. And again, Mr. Baldry has helpfully taken you through the background to the case. For present purposes, it will be no surprise to my lords that the key factual point I emphasise are those concerning Condé Nast's claims. Because although for Mr. Fleming, his two input tax repayment claims, which related to transactions made as long ago as 1989 and 1990, were both immediately out of time when the new 3-year limitation period came into effect under the newly enacted Regulation 29, brackets 1, capital A, close brackets, which came into effect from the 1st of May 1997. That was the position for some, but by no means all, of the Condé Nast claims. The Condé Nast claims for repayment of input tax in respect of expenditure on staff entertainment included expenses payments made between April 1983 all the way to April 1997. So for Condé Nast's expenses incurred at any time between May 1994 and April 1997, they had a period up to 3 years to bring their claims, depending of course on a particular date when the expense was incurred, as at the date that the new time limit took effect. So just to give you an obvious example, if an expense had been incurred in April 1996, as of the date in which Regulation 29(1)A came into effect in May 97, Condé Nast would have had 2 years to make its input tax claim for that April 96 payment. And yet, as my lords have seen, the House of Lords disapplied the new limitation period, both for Mr. Fleming and for Condé Nast, for all of its expenses claims, not just those which disappeared in the puff of smoke on the 1st of May 97. Can I start, please, with the speech of Lord Hope? I'm going to go relatively briefly through the passages that Mr. Baldry has already taken you to, but, and I intend no criticism of him, there are some very important passages in the judgments, speeches of their lordships, which he did not take you to. So we see the statutory regime, which I have sought to set out or summarise already in paragraphs 2 and 3. Then there is reference to the M&S and Grundig decisions of the Court of Justice. And then at the bottom of paragraph 5, in the last line of page 44 of the bundle, whatever the reason may be, it is plain that the unmodified time limit in Reg 29(1)A is incompatible with EU law. Why? Because it is retrospective and because it makes no provision for any transitional arrangements. That is the principle which Lord Hope derives from M&S at paragraph 38 and Grundig at paragraph 37. Indeed, that much was common ground. The question which your lordships must resolve is how to apply the guidance given in M&S and Grundig in order to make good the lack of a transitional period for the application of Regulation 29 to accrued claims, sub silentio, including those which did not disappear in a puff of smoke, resulting from a failure to deduct input tax. Legislation that is incompatible with EU law must be disapplied, but can the court go further and make good the defect which has led to its disapplication? The problem is far from easy, as the division of opinion in the courts below and in this House clearly demonstrates. The possible choices, and I'll come back to these, were identified by Mr. Vider's helpful analyses, which Lord Walker has set out in his speech. Underlying these possible choices is a more fundamental point, which I would express in this way. Where national legislation is defective because it lacks the transitional arrangements that are necessary under EU law, is it for the national court to make good the deficiency by devising such transitional arrangements as it may regard as appropriate? To which the answer given by the majority was no. Or must this be left to the legislature, or following the example of what was done in regard to Section 80 by means of announcement, to the commissioners? Then Lord Hope distinguishes two situations, essentially one where the period was inadequate, the transitional period, and the other, which is where there is no transitional period at all. And then he says in the last sentence of paragraph 7, there is a difference in degree between them, which affects the ability of the court to make good the defect. Then in paragraph 8, he explains that Grundig deals with the first situation. And then in paragraph 9, the other situation is that which applies in the case of these two appeals. Here too, the guiding principle is that of effectiveness. Account must be taken of the principle also of the protection of legitimate expectation. The principle of legitimate expectation is infringed by the retrospective introduction of a time limit for the making of claims retrospectively. But this will not be in breach of EU law so long as transitional arrangements are included which allow an adequate period for lodging claims which persons were entitled to submit under the original legislation. Sufficient notice of these transitional arrangements must be given to ensure that the exercise of those accrued rights, all of them, is not rendered virtually impossible or excessively difficult. Unless this is done, there will be a breach of the principle of effectiveness. And then paragraph 10, I think my learned friend did read out. He says in a suitable case, he wouldn't rule out the possibility of the court reaching its own decision about what a reasonable time limit might be, but not in the situation at issue in Fleming, which is essentially the same situation as we have in our case, where he says, just above letter C, the issue is not one of statutory interpretation for which the court must accept responsibility. There is a gap in the legislation which is unfilled. The infringement of EU law cannot be said to have been comparatively minor or inadvertent. Paragraph 11. To be compatible, and this is a passage that Mr. Baldry did not take you to. To be compatible...
Sorry, can I just take you back to the final sentence of paragraph 10, please?
Yes.
That may be important.
The primary responsibility for giving a clear indication to taxpayers as to where they stood with regard to the making of claims, despite the retrospective introduction of the time limit, lay with the legislature and the executive. My Lord, I'm grateful for you reminding me of that. It is important. To be compatible with EU law, taxpayers were entitled to be told in advance of any transitional arrangements that would enable them to submit late accrued claims for the deduction of input tax, despite the introduction of the time limit. And then I won't read the whole of the rest of that paragraph, but in the last 3 lines, I do not think that the gap in the legislation could be made good on a case-by-case basis. The nature of the defect is such that a single solution is required that can reasonably be applied to all taxpayers. Who are all the taxpayers he's referring to? Those with accrued rights. For these reasons, and for those more fully explained by Lord Neuberger, I would hold that the period has not yet begun, and that it is for Parliament or the Commissioners, if they choose to do so by means of an announcement, to introduce prospectively an adequate transitional period. Until that is done, the 3-year time limit must be disapplied in the case of all claims for the deduction of input tax that had accrued before the introduction of the time limit, not just those that had disappeared in a puff of smoke. I would apply that reasoning to Mr. Fleming's case as well as that of Condé Nast. As we will see, the others agreed with him. And although Mr. Baldry did not take you to this passage, he also did not offer you any answer to it. Then Lord Scott, can I focus please?
Could you, I'm sorry if this is inconvenient, you said all the others agreed with what Lord Hope said in paragraph 12.
No, not what Lord Walker didn't, and I'll show you where the others agreed.
If you could just tell us now what the paragraph numbers are, where we find that agreement.
Yes,
It would
Lord
save quite a lot of...
Carswell agreed with Lord Hope and Neuberger, see paras 76 and 77. Lord Scott didn't mention Lord Hope, but as I'm going to show you, he effectively said in different words what Lord Hope had said.
I see.
And Lord Neuberger agreed with Lord Hope at paragraph 109.
Thank you.
Now, if we can look at Lord Scott, please. Again, I don't think we've looked at this so far. Paragraph 19, at the foot of page 48. The Commissioner's contention on the appeals now before the House, based on paragraph 41 of the Court of Justice's Grundig judgment, is that community law requires only that the time limit be disapplied to claims brought within a reasonable period from the introduction of the time limit. Essentially, the same submission that Mr. Baldry makes. They contend that if a claim doesn't make a claim, claimant doesn't make a claim until several years after the imposition of the time limit, then the time limit can be applied to the claims in the interest of finality and certainty. These contentions cannot, in my opinion, be accepted. Immediately prior to the addition of paragraph 1A, both Mr. Fleming and Condé Nast had rights to recover input tax from the commissioners without any time limit for bringing their claims. That's all of them. And then at letter B, a distinction...
Just
Sorry.
2 sentences on from the sentence you read.
Yes.
The addition of paragraph 1A purported to invalidate those claims forthwith with no prior notice or warning given. That seems a bit odd because it didn't invalidate all the claims.
I would accept that. Yeah. If one then looks at paragraph 20, picking it up at letter E. Now let's start at the beginning of paragraph 20. My lords, I would for my part reject the premise on which the two alternatives contended for by Mr. Vida are based. The UK instituted a VAT scheme for the repayment by the commissioners of input tax that enabled claims for repayment to be made without limit of time. That was a surprising, perhaps unintended feature, but it was a lawful feature. No suggestion it was contrary to the 6th directive. The scheme was then amended by the introduction of a 3-year time limit that was to apply not only prospectively, but also retrospectively with no transitional period during which those like Mr. Fleming and Condé Nast, who had been sitting on their claims, would be able to take into account the change in the law and bring their claims before they became time barred. Whether a reasonable transitional period for claims to be brought that on the 1st of May were already at least 3 years old, should have been 6 months or 12 months or some other period, is open to argument, but is not in point. The important fact is that there was no transitional period. The VAT regime is not judge-made and is not made by the commissioners. It is a statutory scheme consisting of primary legislation made by Parliament and secondary legislation made by others under powers conferred by Parliament. And then over the page, please, paragraph 21. It is argued alternatively that the court can and should fix the duration of an extra period, a transitional period, what Mr. Baldry might call an inherent transitional period, that must be allowed to claimants whose pre-1 May 97 claims would otherwise be barred. It is to me a surprising proposition that the court can, by judicial legislation, add a transitional period in order to cure the invalidity of a statutory provision that would not otherwise comply with European law. There are, to my mind, several objections to the proposition. First, it is not the function of judges to legislate. Second, the principle that people must be expected to know the law and conduct their affairs in accordance with the law can hardly apply to a judicial amendment to primary or secondary legislation that, until it is made known in the judge's pronounced judgment, is held in pectore. The objection to retrospective legislation would apply here too. Third, the important principle of certainty can hardly be satisfied. The terms of a judicial amendment might change as the case travelled up the appellate chain. A rather prescient sentence next. And the ability of this House to depart from previous decisions would need to be kept in mind. Then...
So just before you leave that point, Mr. Grzyński, obviously I see the force of the point that's being made, but we know that in the context of EU law, some very surprising things can and sometimes must be done. Pursuant to the Marleasing principle, words sometimes need to be read into legislation.
Yes.
I'm just wondering how, if one wants to use pejorative phrases, one could describe that as judicial legislation. And another way of looking at it might be that that's how you render legislation compatible with the law.
My Lord, Mr. Baldry in his submission, in his skeleton argument, referring to Hurst, says essentially you can Marlease the position here. But that was a concept essentially grappled with and rejected by their lordships for reasons I will show you.
Yes.
And an important point to note in that context, as my Lord Justice Newey observed yesterday, is that Parliament has introduced Regulation 29(1)A, or those acting under the delegated powers conferred by the Act have introduced it, without any transitional provision, 2 years, slightly over 2 years, after the judgment in Grundig, and just under 2 years after, just over 2 years after the judgment in Marks and Spencer, and just under 2 years after the judgment in Grundig. So it can't be said that those promoting that legislation would have been ignorant of the seminal decisions of the Court of Justice in that case, particularly the M&S case, in which the revenue was a party. So there has been a conscious choice not to introduce a transitional period. And so for the court to introduce one through the Marleasing principle would be to go against the grain of the legislation. I'm using Gaydan and Godin-Mendoza type language. But that's essentially, although they didn't articulate it in precisely the way I've just done, what the majority of the House of Lords have said.
Yes, I see.
Yes, and as my learned junior no, he's not my learned junior, my learned friend, sorry. He was at the beginning anyway, has reminded me, indeed, in fairness to myself, I would have come back to, what the transitional period would be is a policy choice. It's not an obvious one for judges to rule upon, even though in some circumstances they can. There could be all sorts of policy implications of having a 6-month period, a 1-year period, and let us not forget, in this case, you were going from I don't think I need to say any more. There are plenty of policy reasons why you might have certain periods of time, but that, as the House of Lords has said, is not the point. The point is it's not for the judges to insert one where Parliament or those acting...
We can review it afterwards.
You can review it afterwards.
To assess its reasonableness.
If it's there at all.
But, yeah, if it's there. So that's not impermissible. That's indeed performance of the judicial duty.
Indeed.
But your submission is that if it's not there, it's not part of the judicial function to start inserting it into the legislation.
My Lord, yes. And it's not just my submission, it's what their lordship said. Can I just show you paragraph 22? The notion that a court can add a transitional provision to Regulation 29(1)A and thereby avoid the need to disapply the paragraph in relation to 29 claims based on some pre-1 May 97 input tax payments appears to derive from the language in paragraph 41 of Grundig. These paragraphs are set out in Lord Walker's opinion. In paragraph 41, the court said the fact that a national court had held a transitional period fixed by its national legislature to be insufficient didn't necessarily mean that the new period couldn't be applied at all. And then Lord Scott sets out paragraph 41 in Grundy. My lords, he then continues over the page, the court in this passage was dealing with the principle of effectiveness. That is not the only principle in play. The principle of certainty, too, must be taken into account. Taxpayers are entitled to know from the statutory scheme what input tax repayment claims they can bring under Regulation 29. In the absence of any statutory transitional provision, how are they to know whether the pre-May 97 claims that are more than 3 years old can be brought, whereas the claims based on input tax between 1 May 94 and 1 May 97. That's the tail end of the Condé Nast claims. This is not the court overlooking that part of the claim. This is the court expressly covering. This is Lord Scott expressly contemplating that part of the claim. How are they to know whether those claims, how soon they have to be brought? It is no answer to the requirement of certainty to be told that the claims can be brought within an adequate transitional period. There is also the constitutional point, which may or may not apply to judges sitting in Italian courts. It's the function of judges sitting in UK courts to disapply UK legislation that is inconsistent with community law. It's not the function of judges sitting in UK courts to amend UK legislation that is inconsistent with community law. And then he cites from the Commission and United Kingdom case, incompatibility of national legislation with community provisions can be finally remedied only by means of national provisions of a binding nature which have the same legal force as those which must be amended. Mere administrative practices cannot do this, nor can judges.
And is that going to be a convenient moment, Mr. Krasinski?
Oh, yes.
Chuck.
All rise.